Censorship, Suppression and Liability under UK law. A hypothetical analysis of foreseeable harm, digital erasure, and responsibility. Purpose and scope. This paper explores, hypothetically and academically, how UK law and moral philosophy intersect. A person holds or is a gatekeeper to credible, time-sensitive information critical to prevent serious harm. Traditional media declines to publish that information. Digital intermediaries or paid moderators suppress the information, overtly and/or passively. Foreseeable, large-scale, preventable harm subsequently occurs. The analysis is non-accusatory, jurisdiction-specific, UK, and designed to clarify responsibility, not to promote unlawful activity. Foundational UK legal principles. Freedom of expression. Human Rights Act 1998, Article 10, ECHR Incorporated. Protects the right to impart and receive information. Applies even to information that is unpopular, disputed, or alarming. Interference must be prescribed by law. Necessary. Proportionate. Freedom of expression is not absolute, but suppression requires justification. Duty of care. Foreseeable harm. UK negligence law rests on 3 pillars. 1. Duty of care. 2. Breach of that duty. Foreseeable harm resulting from the breach. Key case, Caparo Industries plc v Dickman, 1990. Foreseeability is central. If harm is reasonably predictable, responsibility may arise. Visual flow chart, hypothetical scenario. Redacted for sake of immersive reader. Legal position of each actor, UK context. The original messenger. Legal position, lawful if acting. Must avoid defamation, incitement, or recklessness. No general liability for warning the public of perceived risk. Relevant principle. Reasonable belief in risk negates wrong. Moral position. Strong ethical duty to warn where harm is imminent and preventable. Mainstream media organizations. Legal liability. Protected. Responsibility. Context-dependent, patterned refusal across all outlets may raise ethical concerns, but not legal culpability. Digital platforms, moderators and contractors. This category includes social media platforms, paid content moderators, third-party trust and safety contractors. Legal frameworks engaged. Human Rights Act 1998, Indirect Horizontal Effect. Online Safety Act 2023. Common law negligence principles. Platforms lose neutral intermediary status when they actively remove content. Do so knowingly, without legal compulsion, in circumstances where harm is foreseeable. Causation and contribution to harm. UK law recognizes contributory causation. A party may be liable if they materially contributed to harm, interrupted the flow of protective information, acted where harm was reasonably foreseeable. The test is not sole cause, but material contribution. Dual harm recognition. Harm to the messenger. Loss of lawful speech. Reputational damage. Psychological distress. Professional and economic loss. Harm to the public. Loss of opportunity to take protective action. Exposure to preventable risk. Disproportionate impact on vulnerable groups. These harms are distinct and cumulative. Complicity versus responsibility. Careful framing. Moment. Where suppression is knowing, incentivized, avoidable. Moral complicity is a reasonable conclusion. Legal assessment. Liability may arise where harm was foreseeable. Suppression was active. Note: a clear causal chain can be established under UK legal principles to argue where lawful, good faith warnings are actively suppressed in circumstances foreseeable harm. Those who intervene may have materially contributed to both the silencing of the messenger and the exposure of the public to preventable risk. This framing avoids accusation while may be used for academic discussion, policy critique, ethical analysis, public education. It does not advocate unlawful action